Final argument for this morning will be in case number 29197, AKC Inc., DBA Cleantech versus United Specialty Insurance Company. Each party will have 15 minutes to present their arguments to the court. The appellant may reserve up to 5 minutes for rebuttal. As you know, the clock has been put up on the wall there, so keep an eye on that during your arguments. If the appellant is reserving time, just let the court know, and I'll also try to remind you when you're getting close. You can be seated.
Your Honor, I just had a question because there are two defendants, two appellees in this case. We understand that we have 15 minutes combined, and we've agreed to split our time to 7.5 minutes.
7.5 minutes each. If you don't know, the court does record the arguments, and we have a YouTube channel, so try to keep your voice up so we get a good recording of you. We've read the briefs and are ready to proceed if you are there.
Thank you, Your Honor. My name is Curtis Alberti. I'm the attorney for the plaintiff appellant, AKC Inc., doing business as Cleantech. And I'd like to reserve 5 minutes for rebuttal.
5 minutes? Very good, thank you. Now, that clock, let me just stop for a second. When you see 5 minutes, you'll be in your rebuttal time. Just
Okay.
You know that. So if you're keeping an eye on that. All right, go ahead.
First of all, I want to apologize for discussing a case involving raw sewage right before lunch. But just a basic overview of the facts. In December of 2014, Jeff Melton, the managing member of a non-party Global Core Associates, discovered a sanitary sewer backup in the Global Core's bar, the Bank Nightclub, at 328 South Main Street in Akron. The sewer backup had been caused by a grease clog. He contacted his insurance company to make a claim for the cost of cleanup. The agent told him to proceed with the cleanup. He also contacted plaintiff appellant AKC Cleantech through its sister company Allen Keith Construction to do the cleanup work. And that cleanup work was at a cost of $63,437. Subsequent to the cleanup on January 7, 2015, Global Core's insurer, defendant appellee United Specialty Insurance Company, denied the coverage for the cleanup cost. Global Core was unable to pay for the cleanup costs themselves. They were in financial difficulty. And so they assigned their claim against Global Core and against one party known at the time to be a possible court feature in that, the city of Akron. Global Core filed bankruptcy shortly after that assignment. Cleantech subsequently learned that the only two businesses that could have produced the grease that clogged the sewer that caused the backup were the adjacent restaurants, defendant appellant or appellee Cilantro Thai Inc. and USAFA LLC, that's Brico, the Brico restaurant. Cleantech, as the assignee of Global Core, then filed the instant action in November of 2016 against United Specialty for breach of the insurance contract that had been assigned to them by Global Core, and for the cost of cleanup and against Cilantro and Brico for the negligence causing the grease clog that caused the backup in the first place. Those parties were sued because United Insurance could have a claim of subrogation for the negligence of those parties. Regarding the Cilantro's motion to strike that was filed and responded to regarding the Cleantech's raising the issue of race ipso locator. The raising of the issue of race ipso locator was in response to an assertion in Cilantro's appeal brief on page 11 that the quote appellant has never produced an expert report that shows that appellee failed to clean grease traps, which led to the backup. This is the first time there's been an assertion in the case that it was the plaintiff's duty, Cleantech's duty at that point, to prove the negative, to prove that Cilantro did not maintain their grease traps properly. And that led to the raising of the issue of res ipsa loquitur, which would be implied throughout the proceedings. In any event, the initial complaint against Rico and Cilantro mentioned that one or both of them had caused the damage, and that they were joint tortfeasors in that sense, and that res ipsa loquitur would be an implied evidentiary means of holding them liable based on the circumstances of the case. As it turns out, the affidavit of the City of Akron's field operations supervisor, Delmas Roy, had established that the particular circumstances here were such that the clog occurred at a point where the only three businesses, the only three users of the sanitary sewer line at that point were Rico, Cilantro, and the Bank nightclub. And there's evidence established that Cilantro and Rico had kitchens that could generate grease, and that the Bank nightclub did not have a kitchen. It was an operation, couldn't generate grease to have caused the clog. Those circumstances would be sufficient, certainly, to overcome a motion for summary judgment to establish that there were grounds for establishing negligence on the part of those two restaurants. And it should also be noted.
Standing that the court addressed as well?
Pardon me?
Wasn't there an issue of standing that the court addressed?
If you're talking about the assignment of the claims against Rico and
I believe that's what it was.
Cilantro, yes, I was going to get to that in a second if I could.
Go ahead.
It should be noted that Cilantro never offered any evidence that they had properly maintained their grease traps. And what we're here on is a motion for summary judgment by Cilantro that is the basis for the trial court's decision, and there hasn't been any evidence provided by Cilantro that they had maintained those grease traps properly. Regarding the assignment, Global Core's assignment, or the failure of that assignment to mention either Rico or Cilantro in the assignment is something that we assert that isn't something that Cilantro can raise as an issue. And in fact, there's evidence in the case, both affidavits from Global Core's managing member and from Cleantech's officer, that the intent was that any tortfeasor, the claims against any tortfeasor would be assigned, because those could in turn be claims that, or those could be subrogated to the insurance claim. And Cilantro is a stranger to that contract. And the only case cited by Cilantro where the issue of parole evidence was even dealt with someone other than the two parties to the contract was the case of SFJV 2005 LLC versus Ream, where two judgment lien holders had raised an issue about a deed and the chain of title to the property involved that they were attacking on the grounds that the contract or that deed should be interpreted within the four corners of the contract. I think a distinction should be made between contracts involving conveyances of property, where those conveyances are recorded, they're public record, they're meant to be relied on by third parties. Whereas the case here, we're talking about a private contract between two parties that a third party stranger is attempting to force an interpretation that the parties didn't intend. Regarding United Specialty,
You're at 5 minutes almost right now.
okay. United Specialty's denial of coverage on the sewer cleanup was the basis, or one of the bases for that case was this court's decision in Rebecca versus Allstate Insurance Company, which demonstrated 2 points. First, that the Ohio Supreme Court's seminal case of Anderson versus Highland House is still good law in Ohio, that the pollution exclusion only applies to traditional environmental claims and not to claims where the source of the damage doesn't arise out of an environmental context. And two, Rebecca distinguished Anderson on its facts between harmful substances released into the environment. In Rebecca, it was heating oil that was leaking into the soil and ended up in a municipal waste treatment plant system. And on the other hand, damages that are where the source of the damage is contained and in a limited space, as it was in Anderson, where a heater in a residential unit generated carbon monoxide and caused the deaths of two of the residents there. The facts in this case today fit the latter category. We're talking about a limited system, only one party that could be affected by the dangerous substance, and whether it's a pollutant or not, under the definition of the contract, the insurance contract. The location of the grease blockage only affected that one premises, and that's the basement of the Bank nightclub. This wasn't a case of generalized flooding. I think the trial court had misconstrued a sanitary system from a storm sewer system and had conflated the backup of water with the backup of raw sewage in this case. Thank you.
All right, you'll have 2 minutes and 39 seconds for rebuttal. Now, you'll split your time to 7.5 minutes each, I guess, or however long you take, and you'll have the balance. All right, counsel, go ahead. Keep an eye on the clock as well.
Hey, please support. My name is Gianna Calzola, and I represent Solange Time in this matter before the court. The facts of the case have been briefed separately and have also been reiterated by counsel. Just to hit again on the fact that the assignment that is at issue here today specifically states 3 separate parties: the United Specialty Insurance Company, Century Surety, and the City of Akron. There's no language in that assignment that brings up any sort of ambiguity. Appellant has now brought in these affidavits from the parties as extrinsic evidence to create ambiguity. The only reason that extrinsic evidence should be brought in is if there is ambiguity on the face of this assignment. Appellant has also argued that Cilantro Thai is a stranger to the assignment and should not be able to assert any sort of argument. However, Cilantro Thai is a party to the case and has a right to bring up these questions. It's clear that the intent of the parties resides in the language that the parties choose to employ. They did not employ any language that could show that any other parties could be brought in. It could have been including but not limited to any and all tortfeasors, but they failed to use that language. So I believe that it is clear that the only parties that could have been included in this are United Surety, or United Specialty Insurance, Century Surety, and the City of Akron.
Were they specifically mentioned, did you say?
Yes, those three parties were specifically mentioned in Cilantro Thai and Brico were not.
Did it say anything like, or any and all claims?
It said any kinds of actions against, so any and all claims, yes, was specified, so,
But limited to those three?
but limited to those three parties.
Thank you.
As far as any arguments for negligence, appellants have brought a claim against these parties regarding negligence, meaning they need to show that there is a duty, a breach of the duty, the approximate cause of the damages. The duty is shown in, one of the duties for Cilantro Thai is shown in the affidavit of, I believe it's Delmas Roy from the City of Akron. That shows that there is a duty to clean the grease traps. There hasn't been any evidence to show that Cilantro Thai failed or breached this duty, that they didn't clean the grease traps. This happened in 2014. This case has been pending since 2016. There's been no inspections, no reports done by appellant to show that we breached the duty. And on top of that, the language says, in the affidavit says that failure to clean the grease traps can lead to sewer backup, which means it shows that this isn't the ultimate cause. They don't have any evidence to show that this is what in fact caused the sewer backup. It just shows that it could be a cause. But again, they don't have any evidence to show that Cilantro Thai breached that duty. And lastly, in regards to the motion to strike on the res ipsa loquitur, it's clear that this was never brought up in the complaint. There were 3 separate motions for summary judgment filed in the trial court, and appellant filed 3 separate responses. Nowhere in those responses did they bring up this theory of res ipsa loquitur. And not to mention, this theory doesn't apply in this case. Res ipsa means that the alleged tortfeasor has exclusive control or management of the instrumentality that is causing the damage. Here, appellant is asserting that it's either Brico or Cilantro Thai. They haven't tied in that Cilantro Thai has exclusive control. There's a pipeline, a sewer line that is controlled by the nightclub, Brico, and Cilantro, so there's no way to prove, or that appellant has proved the exclusive control by Cilantro Thai. So Cilantro Thai would ask that this court uphold the trial court's summary judgment ruling.
Okay,
Good to your word.
Ms. Jennings, you have 10 minutes and 45 seconds.
I hope I don't take all of it, but first of all, I just want to say it's my first opportunity back in front of this court in several years, and I appreciate the new building and the location. I hope the court enjoys it as well, too. The principal issue for us, I represent United Specialty Insurance Company, is the application of pollution exclusion in this case. The exclusion is laid out on pages 3 and 4 of our brief. I'm not going to go over all the language here. I will tell you that it is a standard pollution exclusion. Secondly, I think you heard counsel start off saying, apologizing, this is raw sewage that he's talking about before lunch. I think that kind of makes the case. If this material that was described in pages 1 to 3 of our brief ended up in your tap water, or in your bathtub, or in your swimming pool, I think you would agree that it was polluted, and that you would be in a situation where you're saying this is a pollutant. And when we look at the case law from across the country, which we have listed at pages 4 to 5 of our brief, including the 8th District's decision in Simikowski, we see that raw sewage, human feces, urine, and other waste is considered a pollutant universally. There's no question about this. There's really only one counter argument that's made in this case by the appellant, and that is that the Supreme Court's decision in Anderson should bar application of the exclusion. But I will submit to this court that Anderson is neither persuasive nor controlling under the circumstances of this case, and I'll explain to you the reasons why. First of all, if you look at the Anderson case and you look at the cases that we have cited on page 6 of our brief that are related to Anderson, at the time Anderson was decided, there was a debate going on across the country as to whether or not carbon monoxide released from internal heating sources should be excluded under pollution exclusions. And a number of courts, including the Supreme Court of Ohio, said no, it shouldn't. The majority of courts have actually gone the other direction. Ohio has not readdressed it since then. I don't know that we need to, because this isn't a carbon monoxide case. The important thing in those cases is those were all liability coverage cases. Let me just take 1 second here. I'm sure the court's familiar with this. This policy in question here is a first-party property coverage case. It is not a liability policy. So it's like if you take your homeowner's policy and a tree falls on your house, or lightning hits your house, or a tornado hits your house, or there's a fire or some other covered cause of action, it covers you specifically for the loss that you have to your property. It's not a liability policy like the policies in question in Anderson and the cases that were addressing these things. So this line of argument that somehow this only applies to traditional polluters has absolutely no application when we're talking about an insured seeking coverage for damage to its own property. The only purpose that a pollution exclusion would have in this context is to tell Global Corps, if pollutants are what cause damage to your particular property, we don't cover it. Moreover, when we look at the Anderson case, Anderson is as close as this state has ever come to adopting the reasonable expectations doctrine in Ohio. And the reason why was because of the evidence of Anderson. Anderson was a fractured decision. If you look at the concurring opinion, you'll see there were actually 3 justices, including Justice Stratton, who was one of the most conservative members of the court, a very pro-insurance person, who looked at this and said, there's actually evidence in this case that the insured intended for this carbon monoxide risk to be covered by these policies. And therefore, she and 3 other justices of the court found there were, if reasonable expectations was the kind of thing that would be considered, that there was evidence in the case. There's no such evidence in this case. The only evidence you have is that they made a claim for insurance coverage. There was nothing which indicated that this bar ever intended to have raw sewage be covered in its basement. And in the face of the pollution exclusion, it wouldn't be there. The other thing is this. When we talk about reasonable expectations, 5 years before the Anderson case was decided, this court in Sterling Merchandise said reasonable expectations wouldn't be Ohio law. And a year after Anderson was decided, the Supreme Court of Ohio in Walls versus Valence said reasonable expectations is not the law in Ohio. So the whole theory of reasonable expectations, which is a very progressive theory used in some other states, has not been adopted in Ohio. It's been rejected by Ohio courts nearly universally. Ohio courts have also backed away from this idea of what is a traditional environmental plan, because it's so difficult to figure out. This court, Ravaki, the 6th Circuit in the City of Warren case, the Siemiatkowski case, the 8th District, which, by the way, is very close on point to this case. It's a septic system, and the Siemiatkowski case where people were being made sick by fecal coli or some other type of human feces-related bacteria. And the 8th District said, yes, in fact, this kind of pollution exclusion applies. The Cleantech case, which is the 8th District, where it's in the industrial context. The Silvers case from the 3rd District, which was a broad-spectrum herbicide being applied on lawns that kill all the grass. And the Selm case out of the 1st District, which was an asbestos case in-house. All of them, although they didn't all talk about Anderson, all of them just simply look at the exclusion and say, the exclusion, is it ambiguous? Is it not ambiguous? If so, then it applies. The other thing is this, even if you wanted to go down the path, let's try and figure out what a traditional environmental claim is. Well, I understand why counsel's making the argument, because he has to make it in order to fit it in the Anderson argument. Look at the cases that we have cited at pages 9 to 11 of our brief. Across the country, there may not be very many more issues that are more widely litigated than to having raw sewage backing up on public or private property, including people's basements. This is litigated all the time. It has been found to be a traditional environmental claim across the board.
Why not put raw sewage under the definition of pollutant to make it obviously clear and unambiguous?
It's the same reason why there was the debate that was going on with the founding fathers as to whether or not we should identify every single right that would be under the Constitution or not, because if we begin to list some things and don't list other things, then we have the argument that other specifically listed things aren't there. If you look at the definition of pollutants that's on page 4 of our brief, it's very broad. And again, it's standard. It means any solid, liquid, gaseous, or thermal irritant or contaminant, including smoke, vapor, soot, fumes, acids, alkalis, chemical, and waste. Waste includes material to be recycled, reconditioned, or reclaimed. Clearly, this falls within the plain definition of waste, and that's the reason why courts all across the country have found human feces and urine and other types of things to be a pollutant. In fact, Judge Theodosia, if you go even further and you look at cases from Louisiana and Wisconsin that we have on page 10, these were cases of bat guano, naturally occurring bat guano, where you had colonies of bats leaving their feces, where it was determined that that was a pollutant because it was in a certain place at a certain area that was a contaminant or an irritant that clearly you wouldn't want that in your house. It would be pollution. Likewise, in the Chrysler case, which is out of Wisconsin, you had human urine and fecal material that was treated to be applied on farms as a fertilizer.
And the Ohio cases that decided similarly worded exclusions were not ambiguous?
Sure, the Semikowski, the 8th district. And that was a fecal waste from the septic system as a pollutant. And so that was right on point. And this court's decision, Rabaki, doesn't deal with the waste, but it's interesting because it's almost the opposite of this case, right? In Rabaki, you had it was a liability case. You had heating oil that went out from a private residence into a municipal system. And here you have a municipal system where the pollution comes into the private residence. And so it's just sort of a mirror image of the Rabaki case. And in the Rabaki case, this court, of course, found that the pollution exclusion barred coverage for that. So under the circumstances, we're simply asking the court to affirm what the trial court ruled for us. And we believe that under the circumstances, there should be no question that that's what the outcome should be. Thank you.
Okay, no questions, so thank you for your argument today. And 2 minutes and 39 seconds for rebuttal.
Thank you, Your Honor. Regarding the burden of proof in the case of Cilantro and their motion for summary judgment, the plaintiff at that point isn't required to prove their case. It's up to Cilantro to prove that they weren't negligent.
You have to meet your initial burden.
Yeah, and if there had been some documentary or testimonial evidence from Cilantro that they had done their job and they hadn't been negligent, then we would have been required to respond. They didn't. Regarding United, the source of the pollution is the key here. If it's not from a traditional environmental source, then the pollution exclusion doesn't apply, and that's still the law today, regardless of how many out-of-state cases the Council for United wants to cite. And it should be also noted that United's own claims examiner didn't deny the coverage based on the pollution exclusion. So if you want to talk about what a party should know about what they're covered for, even United's own agent didn't raise the pollution exclusion.
Did that agent say, go ahead and clean it up, we'll pay for it, or just go ahead and clean it up?
No, that was, the instruction to clean up the pollution was made by, I think it was an agent, a sales agent.
Sale?
Yeah, right. But the fact that the claims examiner, somebody who's trained to know that policy inside out, didn't even raise the pollution exclusion, should tell you a lot about what the expectations were. Thank you.
So the court wants to thank both of you, or all three of you, I should say, for the arguments presented today. The court will take the matter under advisement and issue a decision in due course. Of course, the clerk of courts will mail each of you a copy of the decision once the